And actually, this slide that I have up right now, California has this unfair competition law. It's the Business and Professions Code, Section 17200. We see it a lot in the wage and hour class action. It's used by plaintiffs in that context. And the theory is that employers, in the wage and hour context, the employers that don't properly pay their employees, comply with the labor code, have this unfair competitive advantage against the other businesses that do comply with the labor code. So they get to add this UCL claim in there. The one benefit that the plaintiffs get out of it is that it's got a 4-year statute of limitations versus a 3-year statute of limitations under the labor code. So they get to reach back an extra year. So that's why we see it show up in a lot of the wage and hour claims. But we could definitely see that being a claim here for a plaintiff saying, look, this employer is not complying with these requirements, and have a UCL claim there too. And it doesn't mean that there's an additional burden that the employer has to comply with or additional regulations, but it just means that if the employer has to comply with the regulations that are out there, and then it prevents the UCL type of claims. But what's tricky now in California, we've got the CDC guidance that Ann was talking about. We have OSHA guidance, which I'm looking at the CDC's website right now. And I'll share this. I'll put this up on the screen too. They have this great FAQ for employers. And I'll share this link as well. And it's just been updated. They're updating this quite a bit. So it's good to come back and look at. But they've got links to OSHA as well throughout the document. So it's important to look at all of the guidance as well. Here's the OSHA guidance on preparing workplaces. So we've got CDC, OSHA, we have Cal-OSHA, California's OSHA, that's got some regulations. We have California state guidance coming from the governor on these guidelines coming out for restaurants. And now we've got county guidance as well. So whatever county you're operating in, we're seeing a lot of different regulations on the county level on what's required and what's not required. So employers, it's a patchwork, and I know it's burdensome, but you've got to comply with all of these and piece them together. And oftentimes we are looking at the CDC's website, there's some conflicting guidance even within the CDC right now. So you're going to have some conflicting guidance probably between all of these, but I would just go with the most restrictive, most protective to the employee, and that's going to prevent these types of claims. So yep. And if you have any help, need any help on that, reach out. We've got some resources on where to find the county guidance and stuff like that, so we can help with that. But to be honest with you, we're trying to watch that. It's changing daily. They're being updated all the time, even on the state level. So it's good to check in on that regularly. Now, the workers' comp issue, as everybody knows, probably knows, we have this executive order signed by the governor that basically says the presumption is that the employee got the coronavirus. If they tested positive and they've been to work, they got it at work. So it shifts the burden to the employer to prove otherwise, and it's going to be hard for the employer to prove otherwise. So, and then the employee will be covered under workers' comp. Now, some things to keep in mind on this: the date of injury must occur between March 19th, 2020 and July 5th, 2020. So once we hit that July 5th deadline, this won't apply unless we see it extended or anything like that. And I haven't heard any talk about that at all. So it is for a limited period of time to keep in mind. And to the extent we've got our restaurants closed, that will in a way protect, we'll have less employees coming in, protect from these types of claims, but it's something to keep in mind. And it just, there's not a whole lot else I can say about that. It's going to be bad for employers and workers' comp insurance. With that burden, it's going to be really hard to prove otherwise. Before we had that burden shifted to employers, it was going to be hard for the employee to prove causation that they actually got it at work. But now that difficulty's shifted over to the employer.